good afternoon. I'm Luke Swetland with the Santa Barbara Museum of Natural History and Sea Center, and I'm delighted to welcome you all to this, our first Lunch and Learn webinar of 2024, presented by the museum's Planned Giving Advisory Council. For over 100 years, the museum has been committed to education in all its forms, and we're pleased to offer a wide variety of programs to you, the community, at no cost. And that, of course, includes today's Lunch and Learn, which will focus on the critical importance of having the difficult conversations with your family and your friends about end of life and estate plans long before those difficult moments arise. Folks, of course, I hope you might consider leaving a gift to the museum in your estate plans to help ensure the future of this great institution. But the important thing is, when you leave an estate gift to any organization, your legacy is part of something bigger than yourself. And I know for our museum, estate gifts have been instrumental in helping us make repairs, create exhibits, programs, and operate. So it really is a way that we benefit from your generosity and you become part of something bigger. Now, before we get started, I want to just remind you of a couple of cool things happening at the Museum and Sea Center. Our Maximus Art Gallery exhibit, Voyages of Discovery, will be open through March 10th. And this exhibit showcases rare, original illustrations from published reports of some of the earliest great sailing expeditions that were mounted by European science museums. In our Courtyard Gallery, we have a really amazing exhibit called Images of Infinity, a dazzling group of large format images from the Hubble and James Webb Space Telescopes. And of course, the Sea Center is fully open and features our new wet deck. So check out our website, sbnature2.org, to learn more about all of the great things to see and do this spring at the museum and the Sea Center. Now, to get started with today's program, I'll hand this over to my colleague, Andrea McFarling. Andrea?
Hi, I'm Andrea McFarling, Santa Barbara Museum of Natural History's Philanthropy Officer of Legacy Giving. We're happy to share with you this free webinar with helpful information on having the conversation about what is most important in our life, in our healthcare, and in our family wealth and future plans with those who matter most. Today's webinar is presented by Lori Lewis and Tamara Scove. Time has been allotted at the end for questions. Please place your questions in the chat, which you should see at the bottom of your screen. If you should have any technical difficulties during today's program, please email Robert Shutt, and this email will be placed in the chat. Feel free to reach out to me if you have any planned giving questions or need more information. I am here to help you leave your legacy, and hopefully you will keep the museum in mind in your planning. Now I would like to introduce our two speakers, Lori Lewis and Tamara Scove. Lori Lewis is a partner with Mullen and Hensel. She assists clients in preparing and executing estate planning documents to memorialize their testamentary wishes, avoid probate, and reduce or eliminate estate taxes whenever possible, while reducing the likelihood of conflict and promoting efficiencies in administration. Lori is actively involved in the Santa Barbara nonprofit community, including serving as a board member of Hospice of Santa Barbara. Lori is also an adjunct faculty at both the University of California at Santa Barbara Extension Program and at the Santa Barbara Ventura Colleges of Law. Tamara Scove worked extensively in nonprofit management and charitable gift planning, balancing the mission of the nonprofit with the needs and interests of donors. She has also managed the employee ethics program for a Fortune 500 healthcare company. Additionally, she held a realtor's license for several years, specializing in the needs of senior clients. Tamara's interest in being a licensed professional fiduciary developed from firsthand experience when she began helping her mother manage her affairs following the death of Tamara's father. This experience has given her a keen understanding of the nuances of balancing the preservation of the estate maintaining a lifestyle, and planning for potential future needs. Tamara recently became co-owner with Shannon Dalton of Quinn Fiduciary Services. Lori and Tamara, thank you for speaking with us today. Lori, I turn it over to you.
Thank you, Andrea. On behalf of Tamara and I, we are very grateful for the time that all of you attendees are going to give us during your lunch hour. As an estate planning attorney and as a professional fiduciary, we are very practiced at having these conversations with our clients and other professionals, and we think that they're very important. We see in our work how the benefits of planning result in less chaos, more emotional stability, and the right thing happening when our clients have a period of incapacity prior to death or after their death. We understand that this kind of conversation, talking about incapacity and death, is not the easiest one to have. There's a lot of emotional punch to the topic, and also there's a lack of knowledge or education about what kind of choices may be available in one's planning. And we hope that this lunch hour is going to give you an opportunity to feel a bit more confident in having that conversation. We're going to give you some education to help you with that process. And at the end of our presentation, we're going to invite questions. We believe that legal and fiduciary planning should be as important as the other preventative maintenance planning that we do in the rest of our lives. We go to the dentist for checkups every 6 months. We have our cars checked up by our auto mechanics. We are in an era where planning for incapacity and death should be one of those preventative maintenance goals that we all maintain. We understand that planning is an essential part of trying to prepare for the inevitable and try to reduce the emotional impact and the tax impact and the procedural or administrative impact of an incapacity and death. And so we are going to follow along with some slides that Tamara and I have prepared in cooperation with the Natural History Museum to help organize our conversation. We want to encourage everybody to have a conversation before the crisis happens so that your emotional impact of the conversation is not one that is terribly time sensitive and or where all the important players cannot be available for the conversation. It's important, especially for those of us that have family needs, to leave a controlled gift to a beneficiary who has special needs, or where we want to make a philanthropic legacy gift to benefit a charitable purpose that is close to our hearts. For many of us, even though we may know that some of those important issues require planning, we get busy with the everyday aspects of life, including births, deaths, marriages, and divorces. And we aren't as practiced at becoming aware that some of those life experiences are those that are exactly the kind that are pivotal to motivate you to prepare an estate plan. And so now we will go to the next slide. And even though for those of you that already have an existing estate plan, and some of this conversation may be more familiar to you, we do want to encourage each and every person to have an estate plan and to review their estate plan at least every 4 to 5 years so that we can make sure that those important changes in your life, changes in your state of residency, changes in who your designated beneficiaries are, and make sure that your assets are properly accounted for, and you understand how you currently hold title and whether or not your estate planning documents are coordinated well with your assets. Not the least of which, a review in your estate plan is important to have pretty frequently to incorporate changes in law. Currently, we have an estate tax law that is going to sunset at the end of 2025. And for many individuals that have complex estate plans that include estate tax avoidance as a part of the feature and goal of the estate plan, those plans need to be reviewed prior to 2025. If you are aware that there are individuals in your family that for some reason cannot do the planning for themselves because they lack capacity or the ability to articulate their wishes, either through some accident, injury, or illness, they are unable to express their preferences, there are methods to creating an estate plan for those individuals through a conservatorship process, which we'll talk briefly about in a few minutes. We can go to the next slide. Estate planning generally includes planning for 2 different time periods during a client's lifetime. The possibility of a period of incapacity existing prior to death motivates us to prepare financial powers of attorney and advanced healthcare directives to nominate an individual to make financial decisions during that period of incapacity. And then also, we prepare documents that cover the distribution of assets and the administration of those assets post-death. I am going to talk briefly about planning for incapacity and planning for death with respect to financial management. And then after I talk for the next 2 slides, I'm going to hand the microphone proverbially over to Tamara, and she's going to talk about planning for healthcare during incapacity and really how to start to have the conversation with your individual family members and your professionals that support you. With respect to planning for incapacity with respect to financial matters, there are a number of ways in which a financial power of attorney can be customized to an individual client's needs. And a power of attorney can either become effective immediately, and that is called a shifting power of attorney, or it can spring into effect upon incapacity, which will be defined within the power of attorney, either as a certification by a physician of incapacity or a majority vote amongst family members who will be empowered to determine whether or not the holder of the power of attorney is incapacitated. Within the power of attorney, a client has the opportunity to nominate who their decision-making agent should be and alternates. And if a client does not have an individual to whom a nomination is appropriately made, individuals like Tamara and other professional fiduciaries in the community can fill that spot within an estate plan for incapacity. The powers within a financial power of attorney can be broad or limited and can be restricted to only specific acts and can include prohibitions. For example, for those of us that are making annual gifts to individuals that we want to ask our attorney, in fact, to continue to make those gifts during our incapacity, we may choose to have that as a specific act contained within our financial power of attorney, so that can continue despite our incapacity. We will transfer to the next slide. And with respect to planning for the distribution of assets post-death, attorneys and other professionals who are assisting clients with estate plans, including financial powers of attorney and professional fiduciaries, generally speaking, the two documents that are used more often than not are both the will and the trust. These terms of art may be familiar to many of us. We hear about them in infomercials talking about the avoidance of probate. We read about them in the newsletter and newspapers when we hear about celebrity deaths and litigation that results therefrom, or we may have a bit of education that leads us to understand that these documents are important to have, but we may not know why one is better than the other and what purpose they hold for us. Generally speaking, the will is a simpler document. It is called a testamentary document, and it is really used more commonly for those individuals that have less than $185,000 in wealth and or have a lower standard of capacity, where the planner wants to make sure that their client can execute a valid document. It is possible that making the document simpler will allow for the client to be able to meet the capacity standard when they may not otherwise with a more complex document like a trust. A will allows the testator to nominate an executor and alternates in order to implement their wishes, where they can include gifts of a specific, general, or residual nature. And these documents can be prepared both in handwriting in California and be valid, and also prepared in typed writing, which require two witnesses who are disinterested. Wills are designed to only become operative at the time of death, and they can be revoked and prepared with new revisions multiple times before death. And if the testator dies with more than $185,000, a will require a probate administration. A probate administration is a court-supervised administration of a decedent's estate, which naturally includes cost, delay, non-confidentiality of the client file, and some uncertainty with how the judge may rule on the probate. So generally speaking, when clients have the capacity to prepare a trust and or they have more than $185,000 in assets, we generally encourage the use of a trust. The trust allows the settlor, the creator of the trust, to nominate a trustee and alternates, include disposition of gifts, including specific, general, and residual gifts, and the benefits of the trust, because it is a contractual document. It has the ability to contribute to incapacity planning over finances during the client's lifetime, and also avoiding probate. Trusts are generally the vehicle that is used for more complex plans, where we have gifts being administered for beneficiaries over a number of years or over their lifetime. Trusts can be revoked and revised many times through the settlor's lifetime, provided that the trust is revocable. Irrevocable trusts are a more complex type of plan, which generally is related to achieving estate and gift tax goals, and is one of those types of trusts that only can be modified by a court order thereafter. Let's switch to the next slide. And then in following up with the brief comment that I made earlier with respect to conservatorship administrations, where we have individuals that have no incapacity planning prior to an event of incapacity through accident, illness, or injury, the court will provide a conservator via court order to administer the incapacitated individual's personal and financial decisions. And one of those features of a conservatorship proceeding is the availability of asking the court to allow the conservator to prepare an estate plan for the incapacitated adult. That involves a noticed court proceeding. And because a conservatorship involves access to the court, generally where we can avoid it, we encourage clients to do so. A conservatorship can be avoided by the use of a financial power of attorney, which I've spoken about briefly. And now Tamara will discuss the incapacity planning document that is available to provide and a healthcare agent the ability to make healthcare decisions for a client. And we will switch to the next slide. Thank you, Tamara.
The Planning for Healthcare Issues and Advanced Healthcare Directive, it is extremely important that you do this and do it now. So you never know what's going to happen and you might not need it. But having it in place is important. And nominate the person who will do what you want. They don't have to agree with your decisions, but they do have to be comfortable following your decisions. So you want to have a very candid conversation about what it looks like for you and what you want done and how you want it done. And this conversation, we have this often with clients as professional fiduciaries, if they don't have any relatives nearby or any relatives, we do serve in this capacity. And so we schedule a separate meeting just about this topic. Exactly what do you want? If you are using if you have family and you're naming them, but they don't live locally, I encourage you to put someone locally. Even our clients who have family, but they don't live in the state, we encourage them to add us at the bottom because you need an advocate. We have a terrific healthcare system, but you need an advocate locally. So we can go there, we can make certain they have the phone numbers, we can do a conversation with the person you've named. So think about having a local backup. And then this My Care document at Cottage Health is very, very good. It's gone through several revisions and it is excellent. We often, our clients will come to us and an attorney has done a legal document for their advanced healthcare directive, but we also go through the questions in the My Care document that Cottage Health puts out, because the questions have a wider range and more conversation. And so we don't want, if you have a legal document, we don't want you to sign the My Care and have witnesses, because then it will supersede the legal document. But the questions included there are excellent. So I encourage you to take a look at that document. It's gone through a lot of revisions and it's got great information. And we can go to the next slide. So I guess I want to preface this with the conversations is we do the best we can. Nobody knows what's going to happen. We can't predict the future, so we don't know. So nobody knows exactly. We do the best decisions with the information we have right now. And there's no right answer. The answer is, what do you and your spouse or partner or family want? So with that as a preface, that's why Lori recommended that you review those documents every 4 to 5 years, because things change. I would start with, what are our assets? What are my assets, or what are my partner's assets? What is it that we're thinking about in terms of going forward? What is it in terms of going forward? Are we looking to age in place? Do we want to stay at home? Will we need in-home care possibly? Do we have a long-term care insurance plan for that? Do we want to move to one of several continuous care retirement communities in Santa Barbara? We have that option here. And then back to, I think Luke started us with this idea of legacy. What is the legacy you want to leave for your family and for your community? So I think it's not a quick conversation. It's not 5 minutes. It's not the be all end all. You will come back to it, but these are the kinds of questions that you and or your partner want to start talking about to move yourself in the direction of getting this planning going. And we can go to the next slide. So having the conversation, you've got the outline of your plan. Now, who needs to know about it? Well, the fact that you have a plan, everyone needs to know that. Everyone needs to know that you put your affairs in order and who to call and where those documents are kept. So that you need everyone to know. The details, maybe you don't need everyone to know the details because they can change. We're making this plan where we still have time, so those can change, but maybe not everyone needs to know the details. And then in terms of beneficiaries and charities, we see this a lot with our clients. If you are doing a distribution, say to your children, that is not even, maybe you have that conversation in advance, and maybe you talk to the individual about why you're making that decision before you talk to the group. So I encourage you to have those conversations. If you're leaving like the museum or a charity, they would love to know that. They would love to be able to thank you while you're still living, and they would love to be able to honor that gift. If you're not including someone that perhaps maybe you've made a change, think through what you want people to know while you are still there to deliver the message. And then who should administer the trust? That is what we are often called to do. And I will tell you the reason why is grief and money can lead to difficult circumstances. And so often people will come to us and say, we've thought it through. We know what we want to do. We know who we want to take care of. However, I just finished settling my parents' estate and I don't want my kids going through that. It's not that they're not capable of it. It is a difficult time when you lose someone, and that grief can be exacerbated if you are then also in charge of figuring out all of the details and having the conversation. So the next conversation you need to have, I'm going to turn it back to Lori.
Thank you. Thank you, Tamara. So if you choose to work with an attorney in preparing your estate plan, no pre-education or preparation is necessarily required. If you use an attorney who is experienced in this practice of law, they will have a good set of skills in taking your expressions of, your desires, your goals, really how to capture those important aspects of your life that you want to have memorialized, in administration for your beneficiaries after your life. And attorneys then take those expressions that you make and translate them into legal concepts and make recommendations about how best to achieve your goals. Generally speaking, attorneys will have you prepare something equivalent to an estate planning worksheet, which will give you an opportunity to indicate who are you related to most closely, either through marriage or registered domestic partnership, your children, grandchildren, friends and family, those other individuals who are in your close network, who you are going to look to for support in the event of incapacity or death. And then also to describe your assets so that we can understand whether or not all your assets are held in a retirement account, out of a retirement account, in California, out of California, in real property, in the market of securities, and to use that information best to guide you in how to educate you if you did nothing and you did no further planning, how your estate would be administered under the laws of intestate succession, and then how best to use the legal documents, a will or a trust, to achieve your goals and change title to your assets if necessary. One important aspect of creating a trust is to fund it with your assets, to actually change title to your assets to yourself as trustee, and getting that financial information off an estate planning worksheet is critical. When you are talking with a professional, your attorney, your financial planner, your professional fiduciary, and you are curious about who should act for you in a fiduciary role, you can consider those individuals that are in your family that may be the most skilled at communicating, being good problem solvers, have good technological skills, have the ability to be present in the event of an emergency. Historically, we used to nominate the oldest male child, but over time we learned that was a lot of pressure on oldest male children to fulfill a role that they may not be skilled or desirous of. And so culturally, we've shifted away from that kind of closed traditional view and now expand our consideration of nominations to include multiple children, multiple individuals who can act as co-trustees, and when there are no individuals available within a family to act, to consider using a professional fiduciary, both an individual like Quinn Fiduciary Services or others, and corporate trustees as well. Once the estate planning documents have been prepared, it's important to consider who should get copies of them. And while I tend to recommend that my clients keep their documents confidential, considering that they may change the terms multiple times before they become incapacitated or died, it is important to have somebody know where to find the documents in the event of a crisis or an emergency. Certainly your advanced health care directive should be in your medical file with your physician, should be in the admissions office of Cottage Hospital, where they can be accessed by the ER in case of an emergency. And ideally, photocopies of the advanced healthcare directive should be in your glove compartment, in your gym bag, carried in your luggage, so that if you do have a medical crisis, somebody knows how to contact your agents so that they can make decisions for you. Our firm prepares a laminated wallet card that goes in our client's wallet for ease and access. other clients choose to wear an arm bracelet if they have critical medical conditions for which treatment is needed immediately in event of a crisis. And so you want to think about how would somebody be able to contact your emergency medical decision makers if that advanced healthcare directive was not readily available. Original documents are really important to be cared for in a safe location where they cannot be damaged by fire, flood, or lost accidentally. Attorneys often use an offsite storage as a service for clients. Other clients choose to keep them in their safe deposit box. It's important to also know that you can, if you have an estate plan that may be controversial, that may be unpopular, that may be surprising to your beneficiaries, that you have the option, you are not obligated to, but you have the option of notifying individuals in advance of your incapacity or death that a hard decision has been made and that you are making it from the place where you have considered the impact of your decision on others. And it's more important for you to honor your wishes than to potentially manage somebody else's disappointment or hard feelings. Those conversations can be attorney facilitated. They can be facilitated by financial planners and other professionals like tax preparers and professional fiduciaries if support is needed. If a client chooses to self-educate before coming to an appointment, I recommend the Nolo Press Plan Your Estate book. It is written by lawyers for non-lawyers as the reader audience, and it includes some very, very basic overview and examples that helps clients, if they want, to consider their various options in estate planning in advance of making contact with an attorney. Then we're going to turn now to the next slide where Tamara is going to talk with us about questions to think about when you are having the conversations and who are the people that you may want to have the conversations with.
Thank you, Lori. I do want to emphasize what Lori said. The details of the decisions you've made maybe don't need to be shared. The fact that you have a plan, that you've made decisions is important to share so they know to look. So we agree on that, and I wanted to make sure that I made that clear. The first, what do you need to address to feel more prepared? And what does your family need for you to address to feel more prepared? Again, they don't need to know the details, but I will tell you, I learned a lesson from my cousin when his father had a health scare and he got better, but he went and worked with the mortuary and made all the decisions about what he wanted done with his remains, how he wanted it done, etc. And my cousin said, best gift he ever gave me, because when he did pass away, I didn't have to think. I didn't have to make decisions. I knew what he wanted. And I took that lesson and we did the same thing. So in that time of grief, I did not have to make any decisions. He and my mother had prepared all the documents. So it was perfectly easy. We felt like we were prepared to handle it. One of the things you want to look at, it starts with a conversation, both thinking it through yourself and with your family, is what are our values? What is the responsibility with wealth if you have assets to distribute? And then who do you want or not want to be involved? Because this is in your healthcare plan, and I'll use another personal story, so I know I'm not talking about clients. When my parents were filling out their healthcare advisory, my father put my mother as his agent, and then my mother looked at him for a minute and said, I'm going to name Tam. And he said, you are? And she said, yes, because I know she can make the difficult decisions, and I don't think you will. My father was a lovely, caring man, and he would never have said, stop, no more. So he agreed with her. And then he said, I think you're right, but I'm leaving you because I think you can make the tough decisions. So think through, who do you want to be involved? It's because you want them to follow what you're doing. And then the next slide, the people you ask to serve in this role, they need to know. So that healthcare agent, they will potentially, they will also be getting the call saying, they've passed away, what do we do with the remains? So they need to know if you have made arrangements. They need to know where those arrangements are made, as well as the kind of care you want to receive. Your financial agent, and often what we see more and more now is it's not, they name a fiduciary, they name us as a financial agent, and then they call us and say, you know what, I'd like for you to start now because I just frankly don't want to pay bills anymore. I don't want to open all that paperwork. I don't want to gather everything for the CPA to do our taxes. I want somebody else to do it. And then in terms of your trust administrator, they need lots of information, basics. What is the contact info for all of your beneficiaries? People don't change their emails and voice or cell phone numbers as often anymore. You need contact information. Who are the professionals? I know from our standpoint, we always continue to work with the attorney that you worked with, the financial advisor that you worked with, the CPA that you worked with. So we need to know who are all of those people. If you chose them and trusted them, that's who we're going to work with. And details, 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 social security numbers, birth dates. And honestly, when I was new in this profession, the one that surprised me the most was a woman who was 100 plus, but had no family. When I got the phone call that she had passed away, she was on hospice, and I knew what she wanted. We'd had all those conversations, but then they called me because they were filling out her death certificate and they needed to know the name of her parents. And she was born in another country in the early 1900s. So I hadn't asked that. But in her lockbox, I did find her original birth certificate. So the more information, the better. And let's move to the next slide. Yeah. So start on how you want to have that conversation. Think about it in your own head. Practice. If you're someone who writes and you express yourself better in writing, write it down, because that can be your script and help you focus. Go slowly, be patient, let them ask questions, listen to their concerns. You may change your mind several times. So those details don't necessarily need to be part of it, but if you are making provisions for a child in a supplemental or special needs trust, because you know that they're going to need help managing that money, you want to share that. You want people to know that that's where you're going and why. You can always change your mind, and then you want to make sure that your wishes and values are respected and honored. So you do that, A, by communicating them, by giving people as much information as possible, by choosing people and letting them understand where you're coming from. They don't have to agree. You know, we often, I get a call from a client and they say, how do you feel about XYZ? And the answer is, it doesn't matter how I feel. It matters how you feel, because I'm going to follow your trust. So you want someone to carry out your plan after you're gone. And I think in the interest of leaving time for questions, we do have another slide about conversation starters. And I think Lori and I were going to go after this one together. And I can start. It's things like, can I have a conversation with you? I've been thinking about, it can happen after you've seen a movie with someone who passes away, or you've read a book. Can I have a conversation? Can you and I talk about what it looks like when I'm not here anymore? And Lori, do you want to jump in?
And I think that actually attending this event today can be a conversation starter in and of itself. Today, I attended a complimentary meeting that was offered by the Santa Barbara Natural History Museum. The topic was estate planning, and the discussion made me think about my values and how I want to plan for the time where I cannot make healthcare or financial decisions for myself, and what kind of legacy I want to lead. Can we make time for me to share what I learned? And can I ask you to help me make some decisions for myself? And can I support you in making some decisions for yourself? That may be a sample start. This could be one of those conversation starters that helps you bring these topics forward in an educational way to somebody else, and also where you get to request from some support and offer some support to others.
And the one, like I said, I think we're hearing more often and it's a great way to open it, is I was thinking about what happened when my parents passed away and how lost I felt. And it made me realize that I didn't know how they wanted things done, or I did know, and I want to share that gift with you. So I think that one is also extremely helpful. When so-and-so died, do you think it all worked out the way they wanted? And it's good to have the conversations early and often. So it's okay to say, I am perfectly fine. You know, there are no health concerns right now, which is why this is a great time to talk about this, because we don't know. And having just all of us together lived through a pandemic, I think that we're more open to saying, we don't know what's going to happen. So let's talk now when everything is fine.
Yeah. And for many of us that are thoughtful, mindful, have opinions and preferences, these are the times to express them in a way that you individually can be honored and acknowledged. The decisions and your preferences that you make and memorialize in these documents don't have to be the same ones as your spouses, your partners, your children, or your neighbors. They're unique to you. And because of your uniqueness and your thoughtfulness and your mindfulness, it really is incumbent on you to memorialize your wishes in a way where the conversation that you may have had with your loved ones and your family members and your attorneys and your fiduciaries and your other professionals can be remembered accurately, and there is evidence of your wishes, that if for some reason somebody wants to make a decision that's inconsistent with your wishes, there is a document to turn to clear up any misunderstanding, lack of memory, ambiguity, or lack of certainty.
Wonderful. Well, thank you both, Lori and Tamara, for sharing such helpful information with us. We do have a number of questions, and I think the first one is just to piggyback right off of what you just said, Lori, and that is, what if the healthcare agent or your executor has resistance from someone's family members? What do you think someone can do to reduce any such conflict?
A couple of different things. One, being very, very clear about your wishes. Many times people will make an expression, I don't want heroic efforts used at the end of my life, right? Okay, so what do heroic efforts mean for you? I mean, does that mean antibiotics and pain medication for palliative care? Or does that mean I don't want intubation, I don't want chest compressions, I don't want a feeding tube, I don't want to be on a respirator, right? Being very, very clear about what your definition of some more generalized decision or term is very, very helpful. It's also helpful if you anticipate that somebody else that you're nominating to make decisions consistently with your wishes has a different philosophy, a different practice, a different worldview, to check in with them and to see if there is room in the relationship for your wishes to be honored. And if they don't particularly feel that they can show up in that way, to be realistic, the crisis is not going to make the situation any better. To pick somebody who can honor your wishes, and to also know that where litigation can occur is where there is a dispute that can't be reconciled. One child has a memory of a parent wanting a particular form of healthcare planning honored. The other child disputes that. A court can be called to resolve the conflict, and it's really important to have as many of those wishes memorialized in writing to avoid the need for litigation.
Let's see, here's another one. I want to leave a bit more money to my middle daughter because she has taken care of me for several years. Should I tell my other children this now? And how can I approach this without hurting feelings?
Well, certainly preparing an estate plan that does not include equal gifts amongst children certainly has the potency to be misinterpreted, and where potential hurt feelings can occur. Where clients have consulted me with respect to that question, sometimes I say, you know what, it'd probably be better if you arrange to pay your child for his or her services during your lifetime, so that the compensation that is received by that child is felt by them real time, and that your other children don't feel as if the value of their services is being misquantified, right? If a child commits to care for a parent in their final years, but the parent only lives 1 year versus 20 years, the other children may not feel like the disproportionate gift really was well earned. And so it's possible that changing the way in which the client chooses to provide that compensation to the caregiving child may include an employment relationship, or it may include ancillary documentation in the client's own handwriting that can't be very well disputed by the other children who get a disproportionately low gift, to be able to read in their parents' handwriting, not in lawyer language, but in their parents' own writing, why this decision was so heartfelt and important for them, and why they want their other children to honor their decision.
Thank you.
Mhm.
Tamara, I've heard some of the biggest arguments among beneficiaries is sometimes over certain personal possessions that one person wanted and that someone else got or took. Do you recommend to your clients that they ask their family and friends what certain items they wish to receive? Is there a more efficient way to do this so that people are willing to speak up and tell the truth, that they don't want to be named receiving a certain item if they don't truly want it?
So I do think there's real value in asking. So all people are different. So some people will never say, because the idea of you passing away is so, they're never going to say, well, I want to make sure I get this. Others are more forthright and will make their thoughts known. So I think this gets back to have the conversation. One way that I've seen clients do it is make a list of the things they think that have either value in their family, sentimental value, or actual monetary value. Send the same list to everyone, say, bring it back to us. They make the decision based on those lists. So if something shows up on every list, they're the only ones who know it. And then they burn the list. So they've made the decision. That is one way to do it. It is I will just go back to having the conversation and having crucial conversations, which doesn't mean that you're going to do exactly what someone says to you in that conversation, but they've had a voice. And it is sometimes the small sentimental thing that is so important to one person, but if they don't express it, no one else knows that. So this having the conversation, having it more than once, having it with different people at different times, you are the ultimately need to make a decision, but getting that input, I think, is important.
Thank you. Well, we are just about out of time, and I wanted to thank Lori and Tamara. We really appreciate your time and expertise in sharing this great information. Our contact information is on the screen if anyone has any additional questions or would like to talk about specific needs. I think all of us are thinking more about how to have the conversation and about our own end-of-life plans and those of the ones we love. As you consider your estate plan, I hope you might consider adding the museum. I'm available to help with any legacy giving questions you might have. The museum's Plan Giving Advisory Council is hosting our next free Lunch and Learn webinar on Tuesday, May 14th at noon. More information will be sent as we get closer to that date, but we hope you will join us on May 14th as we dive deep into another important aspect related to estate planning and legacy giving. You will be sent a follow-up email to today's webinar with some terrific resources to assist you with your conversations. I noticed in the chat there was a number of questions about the book, along with the link for My Care, and then we have a number of other healthcare directive links that we'll include in there, as well as some pamphlets on having conversations and different ways to get those conversations started. So hopefully the additional information you'll receive after today's webinar will be useful for everyone who attended. So thank you again, Lori and Tamara, and thank you to the museum's Plan Giving Advisory Council for helping to coordinate the presentation. And thank you to all who attended. We hope that you gleaned a few insightful pieces of information out of today's discussion, and we look forward to seeing you on May 14th.
Thank you, Andrea.
Thank you.
Have a great day, everyone.
Okay, thank you.
Thanks.